Yeah, I wish it was simple too. I wish it was simple.
Then I would not have to say so many notes when you walk in my door and you ask me questions. So like, unfortunately.
How many people here are like about to start OPT, or how many people are actual students right now here? And how many are in OPT right now? Okay. All right. And what are your all majors? What do you do? Just shout it out. Video production, music production. Lots of animators. Any animators? Animators, okay. All right, cool. I think we're going to get started here in a second. So before we do start, I will say, and I guess we'll do an official introduction for the cameras in a second, but my preferred style of these sorts of presentations is interactive. So I definitely welcome you to raise your hand, interrupt me if there's something you want to know that I'm saying and you don't want to forget, ask your questions, and we'll sort of, we'll go where the questions take us, not necessarily based on, a boring PowerPoint. So.
Hi everyone. Most of you know me. I'm Violet. I'm one of the SOs with Andy here. So any questions? Always my door is open. I wanted to mention just a couple of things before we start. Thank you first of all for submitting questions in the RSVP form. We got the I can answer these. Come see me.
She's more of an expert than I am, probably, on CPT and OPT and things like that.
Yes, the CPT is brand new for us, so we literally just launched this month. So I know it's going to be an announcement pretty soon that may answer some questions. If you still have questions after, like I said, always helps if you make an appointment or if you stay after. I'm always happy to talk about it to you. So with that said, I want to introduce David is here today. He is a senior immigration attorney at Stone, Gregoric and Gonzalez, right?
That was really good.
It is one of the bigger immigration law firms in LA. So he's here to talk to you about alternatives to that to that H-1B that everyone keeps asking me about. But unfortunately, a lot of people, because we are in the entertainment industry, they're not going to qualify for. So what else can we do? So he's here to answer that.
Yeah, answer that and any other questions that you may have relating to travel or just immigration issues in general. So again, thank you, Violet. Thank you, everybody, for having me here. So I'm an immigration attorney. I also used to be a consular officer. I used to work for the Department of State for about 10 years. So if you guys are all here and have F visas, then you probably, in order to get that F visa, you talk to somebody like I used to be up at the window in order to get that F visa. So I have, I'd say, a pretty good bit of knowledge about how that process works as well. And that's going to be one of the themes that I'll keep coming back to today, is that immigration is really a two-part process. One is here in the United States with USCIS, and that's the petition process, which most of you have heard about. But even if you get the petition and you get status here in the United States, if you want to be able to travel and leave the country and come back and see your families and things like that, then you need a visa. And it used to be that was sort of like a rubber stamp. It was just assumed that if you had the petition approved, then you'd get the visa approved. But as I alluded to earlier, immigration has just gotten really, really complicated, and it's really kind of like a grassy minefield, and you don't know where the mines are, and sort of you're running across it, and there are places where you can get tripped up everywhere, essentially. And so that's why we think it's really important to have good advice from people that know what they're doing as you sort of go forward in this process. So again, any questions, raise your hand anytime. Let's make this interactive, okay? But what we are going to talk about today is, again, the alternatives to H-1B. And we can just start to talk about why is an alternative even necessary. So as I understand, and as Violet alluded to, in the entertainment industry, the H-1B really is just not used all that much. My understanding, it has to do with the sort of certifications that H-1B sponsors have to make. And one of them relates to basically keeping the beneficiaries full-time employed. And a lot of time there's sort of benching, or people sort of go part-time in the entertainment industry. And so H-1B really isn't that great of a fit for that reason. But aside from that, H-1B is just really difficult for anybody. If you've heard about H-1B, you know that unless you fall into an exempt category, which is like nonprofit universities, most private companies, if they want to sponsor for somebody for H-1B for the first time, then they have to go into what's known as the H-1B lottery. And basically, there's 85,000 slots, and historically, I'll show you the numbers, but a lot more people apply. And so the chances of actually getting picked in the lottery in prior years, if you had a master's degree, hovered around 45%. If you only had a bachelor's degree, then it was probably a lot lower than that, maybe 20%. So this year, they've actually changed everything, USCIS, and they've created a new lottery process. And I won't get too into this because that's not really what we're talking about today. But basically, we expect that there's going to be a lot more people applying this year because they've actually made it easier. But because they've made it easier, a lot more people will apply. And so for the people trying to get in through the H-1B lottery, the chances of succeeding are actually going to be a lot lower this year. But you can see here, this is the number of people, the petitions that were submitted for 85,000 slots. So it's really in the 200,000 range the last few years, and we think it's going to be a lot higher this coming year. Okay, so aside from the lottery issue, the other issue with H-1B, and it's really an issue with all work visas right now, is that just the climate in terms of immigration has gotten very restrictionist, let's say, with the current presidential administration. I'm sure you all know that. This is not a surprise to anybody. But specifically what's happened is they're scrutinizing H-1Bs, even Os, based on this executive order called the Buy American, Hire American Act, which basically they're just scrutinizing every employer category with the idea that they want to have more Americans do jobs rather than immigrants, I suppose. And they can't actually change the H-1B laws because that requires legislation. So what they do is create an executive order which basically allows them to just sort of through policies and things like that scrutinize and make it just more difficult to qualify. And I'll tell you how that works in a second. So what we see because of this new scrutiny for H-1Bs and other employment applications or petitions is that there's a lot more denials and there's a lot more RFEs. So does anybody not know what an RFE is? RFE is a request for evidence. Basically, you submit any sort of application or petition to USCIS. They can either approve it or they can give you a request for evidence, which is they're saying you don't qualify based on what you submitted, give us more information. And they're usually written very poorly and they're very confusing and you have to basically provide more information. And if you don't satisfy them based on the request for evidence response, then they'll issue a denial. So that's usually the progression of how that works with USCIS. So again, these are the H-1B adjudication issues. Most of them relates to, and I won't bore you with this too much because you're not really that interested in H-1Bs, but it relates to basically what's known as a specialty occupation. An H-1B, to qualify for an H-1B, means that the job you're in has to be a specialty occupation, and that's sort of a term of art. And it basically means that the job requires a bachelor's degree in a certain specific field. That's sort of like layman's term of what you need for an H-1B. And so what USCIS is saying is all of these jobs that previously were being approved without a problem, let's take like graphic designer, for example. They're now saying, you know what, even though there's a lot of graphic designers with bachelor's degrees, there's actually a lot of graphic designers without bachelor's degrees too. So therefore, it's not a specialty occupation because everyone doesn't need a bachelor's degree to be a graphic designer. So that's sort of the logic that USCIS uses in order to deny cases. And they use sort of similar logic in other categories as well. And this is just an example of what I mean by being more restrictionist. So, 5-6 years ago, that sort of thing wasn't happening because they were, let's say, more welcoming of different arguments or different categories. Questions? We're going to move on from this and talk about what you actually want to talk about. Okay, yes. Yeah. Mm-hmm. Mm-hmm.
But I have an associate in marketing as well. Associate in marketing decisions at top categories. So it's important to find it like your chance about that.
So in that situation, that company, if they want to sponsor you, they'll have their own attorneys, basically. They'll have their own immigration attorneys, and they'll have to decide what your job is going to be. And I can already tell you it'll be in the marketing analyst category, which is another one of those jobs like graphic designer, where it's gray area. So you basically have to provide a lot of evidence. They'll have to do a lot of work. And I won't go into the details. I can talk to you about it after if you want. But essentially, you'll have to go into the lottery, which is happening right now. It happens from March 1st to March 20th. So if they don't enter you in that lottery, oh, okay. So then your opportunity would be again from March 1st to March 20th of next year. And if you get picked in the lottery, then you can submit a petition. But the chances of getting picked are pretty low. Especially if you only have a bachelor's degree, I'd say.
How many are getting picked?
85,000. Yeah.
Out of the 200,000?
It'll be more this year is the problem. It'll probably be like 400,000 this year. Doesn't matter. The sponsor doesn't matter. The only benefit you get is if you have a master's degree in the lottery. Yeah. Mm-hmm. Yes? Yeah, so that's something that they've been on H-1Bs that they've been harping on as well. They're basically saying, it's actually kind of like a catch-22. They're saying, let me step back. So one of the requirements of an H-1B is that the employer has to pay what's known as the prevailing wage, which is the minimum wage in your area according to the Department of Labor based on your experience level. And so there's different levels, level 1, 2, 3, and 4. Based on your experience. And basically, most companies want to pay the level 1 wage. They want to pay the lowest wage, especially if you're coming out of OPT, you're entry level. Well, in theory. But what USCIS, again, in terms of this restrictionist theme, what they're saying is if you're level 1, then by definition you don't qualify as a specialty occupation because you need somebody more experienced, basically. So there's a lot of nonsense basically that's going on, and there's a lot of very tortured logic, let's say, that USCIS is using essentially to justify their conclusions in terms of being very restrictive on these H-1B applications. So they've gotten a lot more difficult, basically. And so that's why, talking about sort of the immigration law market, attorneys are probably charging more for these sorts of things because it's just taking a lot more work in terms of attorney time to actually get these so they can get approved. Okay, anything else on H-1B before we go on? All right. So H-1B is difficult. We've sort of figured that out. And for a wide variety of reasons, other stuff is difficult as well. But because you can't always rely on the H-1B, what I want to do, and the point of the talk, is really get into what possible alternatives are there. And I wish I could tell you that there's these really easy obvious alternatives, but everything that we're going to talk about right now, none of it is necessarily easy. It's more sort of think outside of the box. And how can we, maybe you're not qualified today, but you have a year of OPT. How do we get you qualified by the end of that year of OPT? Or if you have STEM OPT, you'll have more time, for example. Or maybe you leave and go back to your country and then come back. Or, it's all about, these alternatives are really all about that and trying to create a creative solution that's really geared towards each person. And you'll see that some of these categories, they're nationality specific as well. So there's some, we'll get into them, but there's some very lucky nationalities, let's call them, that have preferential treatment, essentially, in US immigration law because they qualify for these standalone visa categories that we'll talk about. So we're going to talk about O1s, we're going to talk about E1s and E2s. So O1 is the extraordinary ability visa, which I'm sure you all know about, being in the entertainment field. E1 is a treaty trader visa, and we'll talk about that too. And E2 is treaty investor. E3 is basically, it's an H-1B, except it's for Australians, and it's sort of like a fast-tracked H-1B. Any Australians here? No, okay. H-1B1 is also a fast-tracked H-1B. It's for Singapore and Chile. Anybody from Singapore and Chile? Okay, so we're going to just skip these slides altogether. It's going to be a lot faster than I thought. TN is for Canada and Mexico. Anybody? Canadians, Mexicans? No, okay. And then we'll talk about the green card categories, which are for everybody, but usually have much higher evidentiary thresholds that you need to meet in order to qualify. So usually it's going to be easier to qualify in the non-immigrant category compared to the immigrant category, but not always. And it depends on your employer as well. And then we'll talk about, leave some time, and I'll answer any questions you might have about travel, visas, applying for a visa, dealing with CBP at the airport, things like that, because I think those are all really important and timely issues, especially because at LAX, who, I deal with LAX a lot and have very good ties with the CBP folks there, but they actually, it's really important to know that they scrutinize students a lot. So if you're traveling with your F visas, whether you're still a student or you're on OPT, it's really important that you're sort of doing it the right way and that there's no sort of unknown red flags in your case that you're not even aware of, basically, because it can be very problematic. Okay. Questions before we start with the O visa? Yeah. Let's go to the end, but just quickly, like we talked about one, I was talking with Violet, but like for example, if you are on OPT and you think your job is you're freelancing, doing freelance work, which maybe a lot of people do on OPT, you leave the country, you come back in, you're trying to come in the country, they take you to secondary and start delving into what you've actually been doing. Maybe they think you haven't been freelancing, maybe they think you've been unemployed for more than 90 days. And now you're out of status, and now they're not letting you back into the country. So that's like one example, but there's other ones. They're searching everybody's phones if they take you to secondary. Drugs are a major issue. If you have, California marijuana is legal, but doesn't mean you should have pictures of it on your phone, which CBP can search. And if they find something like that, they can exclude you from the country regardless of what status you are. So things like that is what I sort of see on a regular basis, let's say. Yeah.
When you come back and they take them and check and everything is okay and then you can go to this country, then there's a red flag there.
What I mean by red flags is very general statement red flags. It's not a specific thing. Yeah. No, I mean, a lot of times they take you in if there's like some administrative issue that's occurring. Maybe there's a problem with your paperwork. Maybe you have a copy of something instead of an original or something like that. Maybe your I-20 wasn't signed, Things like that. Those are sort of more technical, where when they bring you in, they fix the problem, and then you're on your way. It's not sort of the serious things that I was talking about, like drugs or things like that. Yeah.
Yes, I have one question about
Yeah.
that. Well, that, like, I was helping students imaging out their healing instead, so I thought it was like when they get to be on harder. I've never had an issue after that, so I'm curious.
Well, I don't know if you want to discuss the details in front of everybody right here, but they let you in. Yeah, if that happens, then it's fine. It's more the situation where they don't let you in, they kick you back, and then you have to go apply for another visa and deal with all sorts of things, and it's obviously not pleasant. Okay. Anything else before we move on to?
When would you apply to any of these visas when you are doing your OPT? What time?
Great question. So that's a good way to segue here, because that's exactly what we're going to be talking about with the O visa. So the O visa is a visa for extraordinary ability, for individuals that have extraordinary ability. There's two types, O1A and O1B. Since you're in the entertainment field, in the motion picture field, you'd be most likely O1B. You could be O1A. O1A is like for business, things like that, sports. O1A has a higher evidentiary threshold, so it's harder to get an O1A. So we always try to qualify people for O1Bs if we can, which is the entertainment field. So again, you have to file with USCIS here. You could either file for a change of status, or you can file to get a visa abroad. Most people, if they're already here, they'll file for a change of status. And to answer your question, for an O, you file it basically when you're ready. You can file it, if you're ready, if you're like a well-known animator and you have tons of articles about you and you make, you're making good money in OPT and you have great letters and things like that, then maybe you can apply immediately. You don't have to wait even your year of OPT. If you have a sponsor, you can do that. Not everybody has that, is able to do that, basically, because most cases for students are actually quite marginal, because you guys haven't just had that much experience yet. You don't have, articles about you in newspapers or media, or maybe you do, but maybe not enough. Maybe you need more. All sorts of things like that. Maybe you don't know enough people in the industry yet. And so that's part of the strategy, actually, is when do you apply? And I would say for students, you probably are going to be applying towards the end of your OPT, rather than towards the beginning. Yeah. Not exactly sure about that in terms of the immigration part. I mean, you have to get a no objection letter from the union. And so it might have been something, maybe they weren't offering the no objection letters unless she did that. But that's not a strict immigration requirement. But yeah.
So a lot of unions, especially the editors, have this. You need to work a certain number of hours on shows to qualify for the union. So that's separate from the immigration part. Now maybe it will help for the immigration part for part of our unions, that way.
Yeah, you'll get better jobs too. So, which exactly.
But that, like the mentioning, there's like not specific requirements as far as I know, immigration-wise.
Right. Yeah. Let me just finish this and we'll go into the requirements, then I'll take some questions. So you can't self-petition. You need a sponsor. So you need an employer. It could be your own company, potentially, like if you wanted to start your own company that you wholly own. USCIS considers that to be not self-petitioning, usually, if you do it right. So that's an option. Or you can have more of a traditional relationship where you have an employer, or you can have an agent that sends you out on different jobs as well. So there's flexibility there. You can get an O for a 3-year period, and you can extend it for a period of 3 years as many times as you want. So I'll take some questions before we go into the requirements. Yeah, in the back. Yeah, it doesn't matter what you're studying. You just need to, sort of the issue is you have to have some kind of status here in the United States if you want to apply to change status to another status in the United States. I mean, a lot of people will actually apply for O's not even being in the United States. They're just applying from abroad, and they have an attorney that files for them, and then they apply for a visa, and then they come in and they have O status for the first time when they come in with their visa. So there's a lot of different ways to do it. It doesn't necessarily matter what you're doing. What matters is, do you meet these requirements that we're going to talk about in a second? Yeah. Yeah. Yeah, you can apply from abroad, absolutely.
Would you say that the chances would be the same, or is it more likely?
There's no difference.
No difference?
Because USCIS is just looking at a petition. So they don't care whether you're here or not here. The only difference is if you're here and you've maintained status while here, then you can change status, which means you can go from whatever status you're in now, like F, for example, and change to O while you're here. If you're abroad, then you can't do that. You basically get an approved petition, you take it to the consulate, and you apply for your visa, and then you come in. So that's the difference. Yeah.
You said you have an altitude too, like letters and everything. What is enough?
That's what we're going to talk about in a second. Let me, yeah.
If we do get a one, then can we travel and come back anytime, or?
That's a good question. So again, this is sort of like these logistical questions. So if you change status here, then you're sort of stuck in the United States. You can leave, but you can't come back until you get that visa. And this is actually one of the sort of minefields that I was talking about, because USCIS is actually very common, and it's actually very common for students especially. Student cases are not easy. For the reasons that I've said before. So you actually might get approval by USCIS, but the visa interview now is not going to be a rubber stamp at all. They're going to, even though they're not supposed to, they're basically going to re-adjudicate the case. And a lot of these posts, they, for better or for worse, they do a Google test. And they type your name into Google, and if you're there, then you're good. If you have pretty good presence. But if you're not, which a lot of people don't, even though they may have gotten an O approval from USCIS, now you're in sort of the scrutiny zone, where there could be administrative processing. You can be held for a long time. They can send your petition back to USCIS for revocation because they claim to have learned something new about your case through talking to you that USCIS didn't know at the time. So all of these sort of things can happen at the consular stage as well, even if you get approved for the O. So this is, back to my very first comment, where immigration is crazy right now, and it's complicated, and there's potential for problems in a lot of different areas. So just because you think that you've succeeded in one part, it's not the end of the story, basically. No, you can, but if you want to come back, you need to get a visa. So you have to go through that. You go through another sort of process that has its own sort of risk profile, let's say. Yeah. Well, I mean, it's basically what I just said. Like, if you have a petition, you have an approved petition, right? You apply for an O, you change status to O. You're allowed to be here. You can work, you can do whatever you want, but you require a visa in order to come back into the country. So that piece of paper, which is the approved petition, it doesn't actually, if you leave the country, it won't allow you to come back into the country. You need the visa, which is similar to your F visa, which is like a sticker that's in your passport. That's what you need, but it has to say O1 on it. It's not the same. I mean, it's sort of the same. I mean, there you at least have a valid visa. I mean, if you're an OPT, you still have an F visa that's valid. So in theory, you can leave and come back if the visa is still valid. In this situation, you don't have a visa. You need an O visa to leave and come back.
Can you apply for that visa over here?
No, you can only apply for a visa outside of the United States at a consulate abroad.
How long do you think this process is going to take if you go back and
If it's smooth, I don't know, a week, a few days, something like that. See, Violet, this is where all the questions are. I'm not even talking about O1s yet. Okay. Who hasn't asked the question? Here, I think here. For what type of work again? Oh, as an editor. Okay. I mean, they'll have their own immigration attorneys that'll probably assess what is in their best interest as the sponsor. I mean, you'll have, if you want to try for an O, you think you qualify, then you have more control over the process. But if your company wants to go for an H-1B, you'll basically have virtually no control over the process. You're the beneficiary, it's all about the sponsor. And they'll have their own attorneys, they'll work with you, but you have to understand that the attorney is working for the employer, not for you. Whereas if it's an O, there's a little bit more flexibility in that typically. So you had a question, sorry.
If you apply for any of these visas and you get rejected, will that affect your next application?
Yes, absolutely. Yeah, negatively. Yes, yeah. Everything that happens, every single interaction, especially negative interaction, you have at the consulate or at CBP, all of that is in a database that's there basically forever that they can look into. Okay. Anything else before we go? Yeah.
So how much time do you have, let's say, after these for women and part?
Mm-hmm.
After that day, how much time do you have to like either visa or like?
Oh, you mean in terms of a grace period?
Yeah.
After, I believe it's 30, I need to look this up. I always get this one confused. I think it's 30 days or 60 days, 30 or 60. What's the grace period? 60 days for students. Yeah, it's 60. Every category is a little bit different. But yeah, you have 60 days, basically. Yep. Yes.
Let's say that my sibling applied for a H-1B or O-1B visa. Apparently he did not get on status.
You mean applied with USCIS?
My sibling just applied on their own.
Right, but at a consulate abroad, meaning that they had an approved petition and then applied, or they tried to get it here?
I'm just saying as the outcome at the end was denied. And let's say that 3 years later or something, I tried to just like his bad experience affect mine in some sense because I know.
Probably less so, but I mean, I guess it's possible. But
Because whenever you have an interview, it's like
yeah,
they know everyone.
yeah. There's connected cases. No, they do. I mean, it's more like if you came here in F status and then applied for asylum. Then no, I'm not saying that's what you're trying to do. I'm just saying, for example, this is the kind of things where that could come into play. Then, say your sibling now wants to come in as an F, and if they know that you came as an F and immediately applied for asylum and it got granted or whatever the case may be, then they might think that your sibling is going to do the same thing, and then they could deny them. Like that's like one example of how something like that could work. But I think what you're talking about is less likely to happen. Yeah. Okay, ready to talk about O's and the actual requirements? Okay, very good. Okay, so for the O1B, these are, I'm going to sort of explain them in layperson's terms because this is like USCIS regulatory language. But basically, to qualify for the O, you need to hit 3 of these 6 categories. And the ones that we look at most in terms of hitting are E. So basically, E is basically you have significant recognition for your achievements, and it's based on what's known as testimonials. So those are letters, basically. So the idea there is you want to get letters from basically the most influential and famous people that you can in your field. People that you know, or people that are willing to write about you, to meet you, look at your work, and write something about you. And the stronger those letters are, the better it is. And the more high profile those people are in their field, the better it is. That's the one that we're always going to try to hit, because anybody can do that, basically. B is recognition for achievements, and that's again through published materials about you. So that's either newspapers, trade journals, magazines. It could be, online or not online. The idea here is that, and this is where the timing comes into play. So for example, if you're still a student, maybe you just don't have that much written up about you, and like most students don't. But you have a year of OPT. This is the opportunity where, you need to be, more proactive rather than passive. If you really want to get an O1 and maybe work to try to get somebody to write an article about you. It doesn't necessarily have to be in the United States. It could be an article written about you in a publication in your home country. There should be multiple articles, You want to try to create some buzz. You're your own publicist, let's say, for the purpose of the O1 petition. Question in the back. Yeah. They could be foreign. Yeah. Just has to be people in your field. Mm-hmm. Students probably should have more, but we typically, for like good cases, not good's the wrong word, but like strong cases, we do 5 typically. So, just by definition, a student's case is going to be a weaker case. And so you need to try to build it up where you can. So it's not so much, you need more quantity if you don't have the quality. Let's just put it that way. But it's better to have the quality. If you can get the quality, then maybe you can get by with 5. But all of this in O visa, and we'll get to the other categories, it's sort of the same. It's more art than science. It's more, you get all the information as the attorney. You see everything that we have. You look at the whole picture, and then you sort of analyze and figure out, try to frame the narrative a little bit, and see how strong the case is, and then try to fill the gaps, basically, wherever they are. So other things that we look at are, for D, major commercial or critically acclaimed success. Those are usually for big movie stars, but for students, potentially, more and more, we're using social media traction for that category. So, for example, if you have a big Instagram following, I'm talking about like influencer level following though. So like probably 1 million followers or so. That's something that we can use. Like I recently did a case for a influencer that had like 6 million. She wasn't a student, but she came from abroad. And USCIS is actually taking that into consideration pretty seriously, like social media following and that sort of traction. They don't understand a lot of other things, but they do seem to understand that, so that's good. High salary, for a student, that's going to be a tough one to meet, probably. But who knows? You never know. And then the other ones, A and C are kind of interrelated. In layperson's terms, it just means that you have an important position at an important company. Or you've had important positions at important companies, or you've had an important role in some sort of important production. Those are basically those 2 categories. So, if you're doing your OPT at Disney, then, maybe we can make that argument. But again, with the O category, it's all about trying to make the best argument you can. And a lot of it just depends on the facts, basically. Yep. It depends. It means like compared to others in your field, you're basically like in the top high echelon, basically top 3-4%. There's no in immigration. You'll notice, and it'll be the same in the E2 category. There's no usually hard numbers. It's all like very relative, essentially. We're going to get into something called the substantial investment, and it's the same sort of thing where it just depends. It depends on what you're doing. Yeah.
When applying for O1,
Yeah.
letters and newspaper articles, I gather them in PDFs on my computer, and when applying.
No, you just send them to the attorney, and then the attorney, unless you want to do it for yourself, then if you want to do it for yourself, then you would just write up a letter and you submit all the evidence to USCIS and see if you qualify, basically. Okay. Is that a hand or is that stretching? That's stretching. Okay. All right, so that's O's. We're going to move on to the next category unless we have more. Why don't we finish with questions with O's? Yeah, no problem. Every attorney has sort of different thresholds that they would take a case up on. What I said, $1 million is more of a safe zone, because then what you can do, if you have a really high Instagram following, then so you can actually turn that into an argument for high salary too, even if you don't have the high salary yet, because you can get a letter from like a social media consultant that says somebody with 1 million followers can make X amount per post, and that means that they're on the highest salary. So it's a lot of like creative arguments basically you're making in an O application. An O is very much art and not science. It's you're spinning a tale basically. You're framing the narrative for USCIS. To trying to convince them that you qualify for 3 of these 6 categories. It sounds vague to me too. Yeah. Yeah, like all of our clients. Well, I can't tell you the names of, but like the ones that we do are less for students and more sort of like established people in the entertainment industry, like famous directors that are foreign. We have a Brazilian director that you guys probably know of that does like some Netflix TV shows, like that sort of thing. O's can be for anything, actually. It doesn't have to just be for the movie industry. We do O's for famous hairdressers. We do O's for sports stars. We do O's for, you can do an O for a chef. The social media client that I had was actually probably one of the most famous twerk dancers in the world. She has like 7 million followers right now. So, you can do an O for anything. It's really, you have to focus basically the category, like what you're applying for. What is your specialty area, essentially? And then it's all about differentiating yourself within that specialty area. So again, more art than science. And if you think it's vague, it's because you're absolutely right. It is. Yeah, that's the testimonials. So, we, like 5 is probably the minimum that we do. No. It's better to get recommendation letters from people who are in your field and are the most prominent people in your field that you can get a letter from. Yeah. Yeah, I think we would, if I was doing a case like that, I would absolutely, because this is all sort of, like you see, these categories are vague. So it's all about taking the specifics of your case and trying to plug them into the categories in order to say that you've met that requirement. So whatever, it's a creative process, the O visa. And so whatever information or whatever evidence that you think you have to satisfy these categories, you try to plug them in. You try to, write it up so that it's as convincing as possible. I mean, that's sort of our job, but it's your job too. Yep.
Would having your own company in the US help for an O1 application?
No. It might make it easier because then you don't have to find a sponsor or find an employer because you'd have your own company. But in terms of meeting these requirements, it wouldn't, unless you're making money. You have your own company and you're making money, because then maybe you can satisfy the high salary. That's a potential. Anything else on O's before we move on? Yes? Yeah. The legal so there's legal fees and there's government filing fees. The government filing fees, if you want an adjudication in 15 days, you would do something called premium processing, and they'll adjudicate in 15 days. Otherwise, it's like 6 months. If you do that, then you're looking at around $2,000 just in government filing fees. The legal fee is separate, and it's going to, range by lawyer, essentially. And what we do, I can't speak for other lawyers, but we do a consultation initially, and we try to get a sense of the case. And the more difficult we think the case is going to be, the more expensive it's going to be, because it's going to take up more of the attorney's time. It's actually kind of it's an odd sort of catch-22 irony sort of situation, because students probably have the least amount of money to pay for this, but your cases are actually going to be the most expensive from an immigration attorney point of view, because you have the toughest cases. Because if I have a director coming in who makes $10 million a year, that's already has an Academy Award or something like that, I can just photocopy or get a picture of the Academy Award, paste it on with the form that they sign, and just and that's it. And that's it's a $500 case probably of my time, because that person is very well qualified. Whereas a difficult case that requires all of this creativity and framing and things like that, it just takes more attorney time, and that's why you'll find if you go out into the market, it'll just be more expensive. Yeah. But if you want an actual range, I'd say if someone's charging you $3,000, I'd say that's a red flag in itself, because that's pretty low. But I would say $5,000 to $10,000 for a legal fee for a case like that. You can apply any time while you're in status. So basically, you can apply the last day that you're in status, and then you'll have a pending petition. And again, they'll adjudicate it in 15 days. And while the petition is pending, you'll have authorized stay, even though you may not be in status anymore, or even though your I-94, or not your I-94 because you're an F student, but even though you're no longer working or your OPT is expired. Yeah, if you wait until the very end, you can stay, you'll have authorized stay in the country, but you won't be able to work. Yeah, but then you're not going to have status to reapply from. So you'll have to leave the country and reapply that way. You can reapply, but you just can't change status. Yeah, you won't have work authorization, because the work authorization will have expired with the OPT, right? Right, so you won't have work authorization once that EAD expires, regardless of what you do, whether you file a petition, you don't file a petition, it's all about the EAD. If you file a petition, then you have authorized stay. You're okay to stay here, basically, while that petition is pending, but not to work. Yeah, exactly. Yep. not sure I understand the question. Oh no, yeah, we answered that question already. But basically, it's the same. They're again, USCIS doesn't care about that. They're just looking at, do you meet the requirements? That's just a logistical question. Yep. It's like average, yeah, or minimum, like. No. The testimonials are used to meet E, criteria E, which is significant recognition for achievements through testimonials. Yeah. I mean, you could use them for other things potentially, but they're primarily to satisfy E. I mean, I guess you can apply as many times as you want. No. You can apply anytime you want. Because this is so subjective, like oftentimes what will happen is someone will get an RFE, like, maybe they recognize the officer's number, USC, and they're like, okay, this is just a tough officer. They scrutinize everything. People will withdraw when they get an RFE and resubmit it. And maybe they get lucky and get another officer, and then it gets approved. I mean, that has happened. Like, that's not an unusual occurrence in immigration. So, all right. Go. Oh, no. Go ahead. You can apply within a week. That's fine. I mean, they'll see they'll see whatever's in the system. They'll see. It's not like a visa. That's a thing with visa applications, like tourist visas, or when you get into immigrant intent issues. There you don't want to apply like a week later. But for USCIS, there's not really a whole lot of harm. I mean, if you have the money, you're just spending money basically. But if you don't mind spending the money, the government filing fees, then there's no harm.
And as with stamping, it's not stamping anymore. It's like basically getting a visa again if you're going back to that.
It's not a rubber stamp process. You should not assume that it's going to go smoothly. Usually it does go smoothly, and hopefully it does, but there shouldn't be you should be prepared going into it, basically. You need to be aware that it could go wrong, and, if it does go wrong, the reason is usually because of the applicant themselves, because they're not prepared. They haven't usually read their petition. So they're saying things that are inconsistent with what was written to USCIS. That's actually the number one reason usually why a visa that's based on an approved petition would be denied, is because the consular officer is now talking to the person. They've read what the lawyer said to USCIS, and now they're verifying it, basically. And so if the applicant isn't prepared, if they haven't really gone through and make sure they're on the same page with what was submitted previously, it could be very, very problematic. Very problematic. Who hasn't had a chance? You.
Months after your OPT is over, and what if you apply that on your 30 days after your OPT is over for the O1?
I mean, I wouldn't recommend doing that. I would probably.
Do it while
I would recommend doing it maybe like a month before the OPT expires, because that'll give you time to still be in status if you get denied. So that's the ideal situation, because once you do it when you no longer have work authorization and you get denied, then you're sort of in this, you're in this gray area where you have the potential for an overstay, which you definitely want to avoid, because that can affect even like a tourist visa, down the line. So you don't really want to, negatively affect your ability to be able to even come back here as. Yeah, and the other reason again is so that you can potentially explore other options aside from O as well. For who? USCIS? No. But these employment-based applications, they have what's known as premium processing. So if you pay, it's $1,440 right now. If you pay that for premium processing, they'll they'll adjudicate in 15 days. Yeah.
So within 2 weeks, if you're
Exactly.
getting it,
Exactly. Yep.
then you apply to multiple visas at the same time.
You could. I don't know why you would. I mean, in case if you're just like,
I mean, in case the O1 gets denied and then my OPT is over, I guess.
I would just time it in a way where you give yourself enough time to do multiple options consecutively rather than at the same time, because then you're just wasting money probably. But I mean, if a client wanted to do that, I mean, we could do that. It's not. It would be kind of odd though, because if you're approved for both of them, one status could get knocked out by the other status, and then you would have to specify which one is your preferred status. It would get complicated. I wouldn't recommend doing it that way. We might just talk about O's the whole time. Okay. All right. Yeah. Does that what? I mean, depends what you were doing. I mean, we would try to make it count. We would probably throw it in there, but it's all about quality. So. We talked about what it means in terms of how it helps. It doesn't necessarily help directly, but I guess if you're in the union, maybe you can get better jobs, and then that could help with, A and C. Basically, having more high-profile positions could help. Yeah. Mm-hmm. If you fall out of status? If you're in status, then it shouldn't affect your application. I mean, that has its own complications in terms of, going from F to F at a different school and timing and things like that. But I'm sure Violet can tell you all about that. Yeah. Okay, are we moving on? Is anyone interested in hearing about being an investor as a alternative? So this is O. So like I said, all of these options are sort of think outside the box options. I'm not presenting them to you as, these are slam dunk cases or anything like that. They're not. But if done right, they could be a very effective alternative to H-1B. So the next one is the E-2 treaty investor. So unfortunately, this does not apply to all nationalities. And what we're going to talk about, really in the next few categories, applies to a narrow sort of nationality profile. It's specifically countries that have long-standing, or maybe not so long-standing, economic treaties with the United States. In other words, friends of the United States. But friends meaning in diplomatic terms, over a long period of time. So unfortunately, the countries that don't have the E-treaties are Brazil, Russia, India, China, the BRIC countries. So if that's one of you, I'm sorry. The countries that do have the E-treaty, though, are more like the Western European countries, South America, North America, Canada, Mexico, and there's some others as well. Some of the former Soviet Union states have it, things like that. If you have a specific nationality that you're curious about, then South Korea does have it, yes. I'm not sure, but I think yes. But I'm not sure. I don't know. That one I don't know. But we can look it up after if you want. Okay. So the idea behind the E-2 treaty investor typically, not necessarily in your situation, but typically it's used for people that want to invest a substantial amount of capital, of money, to start a business in the United States. So, your most typical type of thing is, they want to start a franchise restaurant, a salad shop, or fast food, or something like that. They invest $500,000 into their company, or something like that. And I'm telling you a typical sort of strong case. They invest $500,000, they build out the store, and they open, or the restaurant, and they open it. They're managing it, and they own more than 50% of the company. So that's like a pretty straightforward, easy case. So that's really not probably going to be your situation, because you're using it as an, again, alternative to H-1B. You're looking to be employed. You're using it probably, for you guys most likely, as sort of a method to be able to freelance through your own company that you created. And so this is possible to do. I won't say it's easy, but it's possible. And again, we're talking about it's more art than science. So again, what you need to do is make an investment that is substantial and at risk. So, the most likely structure for somebody like you is whatever like if you're an animator or music production or something like that, then essentially you're creating a music production. Who is the music production? Yeah. So let's use that as an example. What do you do in music? I'm going to be like outing myself as like totally ignorant of everything that you guys do. So explain to me in layperson's terms, like what is a music, what do you do in music production? What would a music production company look like if you were to open one? Okay. And who would your clients be? How would you do the marketing to get clients? Okay. Yep. Okay. So you basically have to. I mean, that's a lot of investment of capital. That's a lot of equipment. That's a lot of. So that's a good business for an E2 potentially, because you're looking at how big the investment is going to be. So 100,000 is usually like a safe number for investment. You could do it with less, but I think the biggest challenge happens when you start a company that doesn't have a lot of capital costs. Like I'll go back to graphic designer, even though you guys aren't graphic designers here. The last time I did this talk actually at Art Center, where there's a lot of graphic designers. But there they have the problem where, graphic designer is start a company, have a laptop, I can start my company, I just need clients. So, it's a few $1,000s capital investment. So there you have to think of, okay, what else more can I invest into my business to meet this requirement? But when you have something like music production, if you're doing a recording studio, I guess you're renting the space, you don't own the building, right? But you're buying a lot of equipment. So that's a really good potential E2 application, because you can get to the investment level you need. So aside from that, as long as you, and you meet the nationality requirement, as long as you are directing and developing the business, basically you're the boss, it's not a passive investment, you're running things, then it could qualify as an E2. You had a question? Yeah, so again, this is like, you have to look at so you tell me, what does it cost to start a PR firm? You couldn't, so if you hired me to do an E2 for you, my first question would be, tell me what it costs what it's going to cost you actually. You have to think about, like, what is it actually going to cost? Are you going to have employees? Are you going to, there's ways that you can get your capital costs. Like, capital costs means startup costs, basically. So if you're going to have employees, that's a great way to do it. Yeah, I mean, I don't know what equipment you need for a PR company, but I do know that you can prepay a lease. A prepaid lease is a very good way to get your startup capital costs up. The main thing that you need to know, though, is sort of from a structural point of view, how an E2 works is you have to create the company, right? And then you personally have to invest whatever the investment amount is into the company, okay? create a bank account. The company has a bank account. Now it's its own entity. And then, in order for that investment to count, the money has to be expended. It has to be at risk. So it can't just be like, oh, I put $100,000 into a bank account and now I've invested. No, because USCIS or consulate abroad, they'll just say, well, you could easily just take that $100,000 out after I give you the visa. So it's not an investment. So it has to be a situation where you've either already spent the money, or for whatever reason you can't get the money back. Basically, it's all accounted for. So let's see what else.
Yeah, but then let's say I make a film production company, I buy camera equipment worth 100K, and then I spend it all, I don't get the E2, and then I need to leave the country and I invested all my money.
Yeah, so what people will do in that situation sometimes is, although if you went and did all that, you guys actually have really good E2 cases, because the types of things, potential businesses that you could be starting have very high capital costs. So as long as you do it right, I actually don't think that you're in too much of risk of getting denial. The risk of denial happens more when you have these tiny capital costs where it's just you and a laptop and I've started a business. Those are the cases that are at risk of getting a denial. If you have legit expenses of $100,000 to start your company and your nationality qualifies and you meet the other requirements as well, I mean, I'd say those are pretty strong cases, especially if you can show that you already have like clients. That you've developed through this OPT period. So this is actually a good segue to talk about OPT and like how the OPT and E2 would work in concert, because I know you guys do a lot of, who's doing freelance OPT? Yeah, so a lot of people are doing freelance OPT. So this actually works really well with the E2, because you can freelance, and then at some point, if you start seeing that you have a client base, then you can transition and actually, and you want to do the E2. Then at some point during that year of OPT, you can start doing the things that you need to do that are going to help you with the E2. Start documenting the costs, make sure sort of the accounting was done properly, and I can talk a little bit more if you have questions about that. And really, it gives you this runway basically to fold whatever venture you have into an actual E2 application.
Let's say like you have a freelance vendor, I was to say I invest in my own production house and spend a lot of money in good computer.
Yeah.
And I can prove that I spent $10,000, that is great enough.
10,000 is going to be more marginal, but yeah. 100,000 is safe. You could do less. I mean, I've seen cases approved with like 50, or even less, 30. When I was a consular officer, actually, my first assignment was Guadalajara, Mexico, and I was the E2 officer. I did all the E2s there, and it was different than how it was done now. So here's a backup, actually. I should have explained this. So the E2, you actually don't need a petition with USCIS. Like that was how we talked about with O's, where you have to apply here. You have the option to do that. You can apply here if you want, if you change status, but most people actually apply at a consulate abroad. They get the business ready, do everything they need to do. They hop over to their home country and they apply there, and then they get a visa. The duration of the visa depends on your nationality, and then they can come back and work freely. So these days, when you apply at a consulate abroad, these packages can be pretty thick, pretty big, and they take the time, they read everything, they're very, very thorough. There's probably like 2-3 hours of review that goes into each of these applications. So in 2006, 2007, in Mexico, when I was the consular officer, what would happen is someone would come up to the window with a stack of papers like this. I would see them for the very first time as they were giving them to me, and I had to make a decision on their case in 10 minutes, one way or the other, and just skim through, ask a couple questions, and that's how it worked back then. So it's actually a lot better than it used to be. But you're shocked and horrified, it sounds like. But yeah, that's how it used to be, because we had to clear the room. There was a waiting room of 500 people that all wanted a visa interview, and you can't spend, that much time with a person. Exactly, and you guys know exactly what I'm talking about because you've all been in that room. I sort of went on a segue here. So anyways, that's the E2. Any questions about that? Because we're going to talk about the cousin of the E2, which is the E1, which is another way to structure the business, which if you don't have the money to make the investment, you can actually also structure it potentially as an E1 in order to sort of accomplish the same type of goals. But you had a question?
Yes, for the citizenship, that fire born with like the person, or is like, for example, an Indian born person join the Mexican citizenship, and he's still applying to.
Yeah, it's about whatever passport you have. It's not about where you're born. So, a lot of people, so for example, that actually happens a lot where they're nationals of India, for example, where they don't have the benefit of the E2. However, they got citizenship from the big one these days is Grenada, if you believe it, believe it or not. Grenada, where you can buy citizenship, or maybe for some reason, maybe in Spain they got citizenship. Spain is usually a pretty easy one to get through family or something like that. So if you get that second citizenship, and the second citizenship nationality has the benefit of the E2 visa, then you can apply for the E2 visa through that second citizenship. And that's very common. That happens a lot. Yeah. Yeah, so E2 is good. It depends on your nationality, and it changes all the time, but it could be up to 5 years. Some can be as little as like 3 months, and then you just have to keep reapplying. So I would have to just check on the specific nationality. What's good about it though is you can renew it indefinitely. So you can do it forever. You could also roll it into a green card potentially as well. But that's like advanced immigration class. We can talk a little bit about that though. Anybody else? Oh, okay. Going on? Okay, E1s. Oh my goodness, it's 4:45. All right, let's try to, I'm going to skip actually everything after E1 probably. So the E1, it's the same sort of concept. It's treaty-based, so only certain nationalities. Sorry about Brazil, Russia, India, China. Doesn't qualify. But here, if you can't make a substantial investment into a company, you could still, or into a U.S. entity company, you can still do the same thing or accomplish your goals through creating an entity that trades with the United States, essentially. And the trade, the definition of trade has broadened greatly. So when this first started, it was about like import-export companies, right? So trade of goods. But now they interpret it a lot more broadly where it could be trade in services. And so that's when we get into the kinds of things that you're doing, because you're all service industry, basically. So music recording or editing or all of that is a service. Here, though, with the E1, the way you would have to set it up is you would have to create a company in your home country. And you work for that company and then sign deals, contracts with clients, essentially. And if you could have enough substantial trade, which means you translate that into if you have enough regular clients that pay you on a regular basis to do this sort of work, it's possible that you can get into this sort of E1 category. And again, this is the sort of thing that you do in OPT. You're here in OPT, but you start a company in your home country. And the freelancing you're doing with on OPT, well, maybe it wouldn't work so much with OPT. Or maybe you're doing it in OPT as freelance, but then once you're done with OPT, you sort of transfer it over to your foreign company, basically. That would probably be a better way of doing it. But then you establish the trade, and then if you can do that, and you satisfy the other requirements, but the main one is the trade and services, then you can actually get a visa, even though it's for a company abroad that's doing business with the US, you can actually have a visa to come and come and go in the United States, including living in the United States and providing those services. It's kind of like, it doesn't make a whole lot of sense, but it does actually work. It's kind of confusing because it's a foreign company entity, and you're here, but it is a possibility if you structure it that way. So this is sort of the alternative when maybe you can't afford the substantial investment. Yeah.
So for example, I would hope you are recommended for earning Holland
Mhm.
from,
Yeah.
and I would have investment clients.
Exactly.
So I can identify but in the US.
So here's the main thing with that is you have to have over 50% of your international trade with the treaty country, between United States and the treaty country. So basically, in that situation, you can have as many Dutch clients as you want, as many as you want. That doesn't matter. But you have to make sure that your international trade is over 50% with the United States. So if you start getting French clients or German clients or, you know, whatever the case may be, you have to make sure that it doesn't eat into that international trade number. It's measured more in like revenue, but not necessarily in clients. Yeah. But I mean, that's sort of advanced at that point. That's where like you already have the visa. And this is about maintaining the visa and renewals and things like that. But again, this isn't the sort of thing that like you do lightly. Both the E2 and E1, I mean, you could try to do it yourself, but I wouldn't. You really should hire an attorney to do this sort of thing because, you know, I'm giving you sort of the overview, but there's all sorts of sort of technical details of like how you structure things and, you know, what contracts specifically need to say to comply with the E2 rules, how you transfer money. I can't tell you the number of times that I've seen, you know, cases come into our office, you know, where they were with somebody else initially, where somebody got denied after, you know, there's one case I off the top of my head, you know, they invested $400,000 into a business, but because the money came from a parent, and the parent it was a gift, that's how they got the money. The parent deposited directly into the company bank account rather than the person depositing, they got denied. So it basically just killed the whole application. Yeah, exactly. Yeah, it has to be a personal. Well, at least that gives you a 51% ownership interest. Yeah. Yeah. So taking outside investment, that's a whole different issue, and that there you get into the issue of do you maintain your 51% ownership or 50% ownership in the company? Because once you take outside investment, say it's a high growth company, for example, you have to really be paying attention to the cap table. Because if you go under 50% on the cap table, then, I mean, it's still possible to qualify, but then it gets a lot more complicated, basically. So there's a lot of moving pieces, a lot of moving parts in getting the initial E2 or E1 and maintaining the E2 and E1. So it's really important. Your immigration counsel is basically an essential partner for you in your business, really. Not that, you know, you're talking to them all the time, but, you know, in certain periods of time when the visa is very important. So, you know, you should really, if you're going to try to do one of these categories, E1 or E2, you should be very confident that the immigration attorney that you go to knows what they're doing. Because I'll just leave it at that. Because, like, this is no joke. Like, you really need to know what you're doing as an immigration attorney for these categories. Okay. Questions? Everyone's somber now. I think we're nearing the end, actually. It's 4:52 already, but let me see what else we have here. So we're going to skip this. There was nobody here that's Singapore or Chile. No Australians. No Mexicans or Canadians? No? Okay. So we can just quickly touch on green cards, even though this isn't really the focus. So EB1 is basically the equivalent of an O, but with a much higher evidentiary threshold. So if with an O, let's say to get an O, it's, you know, down here, you know, you need to be kind of extraordinary, you need to have some stuff, but, you know, students can get it, you know, if you do things right, here, like, you probably can't go straight into, like, a student would find it very difficult to go straight into EB1. This is where you have an O for a while, you build up your career, and then, you know, maybe after a couple O's, then you do an EB1, basically. The requirements are more or less the same. They're a little bit different because they combine the business and motion picture categories on EB1. So it's like 3 of 10 this time, but it's the same idea of what we talked about before. E2 and EB3 is basically the green card equivalent of an H-1B. But there, and again, I'm super simplifying these terms because we have like 5 minutes here. But there, basically, you need someone to sponsor you, an employer who wants to sponsor you for a green card. And what they're doing is doing a test of the labor market. They basically have to prove to the Department of Labor and USCIS a number of things. But the main one is that there's no other person in the United States that's willing or able to do this particular job that they're sponsoring you for. And that might seem like that's a really tall order, but there are certain ways to sort of accomplish that goal. And you actually do like a real recruitment where you have a period where you put out ads, or the employer has to put out ads for the position, and, you know, essentially disqualify anybody who's either applies for the job or not disqualify them, but they basically have to have nobody either apply for the job, or if they apply, they're not able or willing to do it. And that's the only way you can sort of get this type of green card. But it's actually easier than I'm making it sound because I'm really simplifying it. Yeah. Mm-hmm. If someone's willing to sponsor you for a green card, it would be good. Yeah, it's a better option. It's actually probably these days, because of the lottery, it's actually easier than H-1B. The challenge, though, is that that process takes about 18 months, and so from start to finish. And so you need to have some sort of, if you want to stay here, you need some sort of status. So it may be that you have to leave the country while the 18 months is going, and 18 months is if everything goes smoothly. You know, you could hit recruitment and they find somebody for the job, and then they have to do it all over again. So it delays things. So again, a lot of moving pieces there in terms of logistics of where you are and things like that. So, you know, usually people are sort of doing the green card option and the non-immigrant option in parallel somehow because they want to stay here, right? Yeah. I mean, they could sponsor you for either. It's just, they're totally different tracks, basically. And, you know, it's very common to have those tracks going in parallel. Yeah. Usually it's like H-1B and these EB2, EB3 in parallel, but I've seen E2 and EB2 in parallel as well. So you can do it any way you want. Yep. Again, it's just, it's what I said. It's the same basic requirements in terms of the substance. It's just the evidentiary threshold is now higher. They want to see more. So, you know, if you would qualify for, you know, there was that prong about media articles, right? Maybe for an O, you qualify for, if you have 3 articles, 2 of them are from, you know, your home country, you know, your hometown paper or something like that, and one of them is, you know, an indie magazine in Los Angeles or something like that. For an EB1, to satisfy the same thing, you know, they're going to want like the Washington Post. Like, that's what I mean in terms of qualitative difference. I don't know. I'm just giving you like an example. Like, all of these cases are like totality of the circumstances. It could EB1. It's the same sort of thing. It's 15 days if you do premium processing, so you can get an answer immediately. But then there's a net step 2 process, which is getting a green card. And that, you can either try to do it at a consulate abroad, or you can do it while you're here. If you do it while you're here, right now it's running like 8 months. Just the process. Yep. All right. I think we're wrapping up here. I guess the last thing, I mean, we've been talking about this throughout, but I will say, we talked about the visas. Even if you get a petition approved, one thing that you should remember is that the visa interview itself, it's not a rubber stamp. Take it seriously, prepare for it. Not all attorneys will focus on that, immigration attorneys. So if you have another immigration attorney, you're going through this process, remember me. I might not be your attorney, but remember what I'm saying, because you have to take it seriously. You have to read your petition. You don't want to go through all of this time, money, heartache, blood, sweat, tears that you're going through to screw it up basically at the very end. It's like it's a complete unforced error to get denied on an O petition. And it typically only happens when applicants aren't taking the process seriously, and they think that it's just a rubber stamp. That's what my lawyer told me. It's, I wish it was that. Maybe 5-10 years ago it was like that, but we just live in a different world right now in terms of immigration, and it's just not like that anymore. In the back. Exactly. That's probably for EB2, yeah. Yeah, I mean, they'll ask for all sorts of stuff, basically, whether they have the right to it or not. It's impossible for me to tell without actually having a consultation and debriefing somebody. The only way to find out is, my process is if someone comes to me with that sort of problem, I ask them what happened at the interview. I ask them to tell me word for word whatever they can remember. So, it's like reading the tea leaves to figure out what the problem was. Yep.
So if I apply for O1 and I get approved, I still gotta fly back to Germany and get my visa there, right?
If you want to travel. If you're fine just staying in the United States, then you can just stay in the United States.
My O1 approval.
Yeah.
So the visa itself is only there for me to leave and enter.
Exactly. Yeah, if you're here and you've maintained status this whole time and USCIS changes your status to O for a period of 3 years, you can be here for a period of 3 years. It's just the problem is when you need to leave, and usually when people need to leave in that situation, it's like an emergency or something like that, and it's just very inopportune, and then you add an emergency with having to apply for a visa, it's a huge headache, obviously, and it's very stressful. So, I think people in the industry typically, especially industry people who are, have a little bit more experience and more notoriety, they all want the visa because they're traveling internationally all the time. And so that can also be a challenge because people in the entertainment industry they're not necessarily in their home country. They're, on shoots or things like that. And so we deal with those sorts of issues all the time as well. Okay, and then the last thing is, it's the same thing with CBP at the airport. We talked about it a little bit up front. I guess the only thing that I would say, and this applies not even to O's, but to you as F students, basically, when you're coming into the country, look at your phones, look at the pictures on your phones, and if there's something on there that you think that would be problematic, you should keep that in mind. Because they can search your phones. Your phones are subject to search, even if it's suspicionless. They don't have to have if they refer you to secondary, you could assume that they may search your phone.
I was secondary once they did.
Then you're lucky. But if they have suspicions about you, then they can search your phones. And so, sort of the worst cases that I've seen is, again, going back to the drugs and marijuana. It's usually relating to that, where the person comes in, they have a quick, it's usually a quick question from the CBP officer, like, so tell me what you study. This person just got off a 14-hour flight and is brain dead, right? Which you guys probably all experienced. And, mumble some answer or something like that. And the CBP officer just doesn't like what you said. They're like, I don't understand why you can't explain to me what your major is or what you do. You're going to secondary. We're going to talk about it. So it's like those sorts of things where it's just like an initial thing like that can turn into a whole big thing, because now you're in secondary. Now they can search your phone. Now they're sitting you down and they're just looking through. And people, they're not necessarily extremely wise with the pictures that they have on their phone, and it can really get you in trouble. And I've seen it firsthand with many of our clients, and it's really sad. So with that, on that somber note, I guess we should have finished on a here, maybe you have a question that will allow us to finish on a good note. Oh yeah, everything. Basically, their rule is that they can't search anything on the cloud, but if it's on your phone, then they can search that. I'm not surprised. Yep. Exactly. All right. Well, on that note, thank you very much for chatting. And I have some cards here if you guys want some cards.
Yeah, you're also asked in my office again if you guys have any additional questions about anything, or need to get in touch with David, I'm sure.
Can you write your email over there?
Say again?
Definitely write your email on your
I
card.
have cards.
Yeah. They're all just.
Thank you so much.
I'm not very
for all
organized
this.
here. Yeah.
Very complex.
It is very complex, and it's gotten